If a chemical fire breaks out at a warehouse, who should be held responsible for the cleanup? The landowner or the waste generator? In United States v. Monsanto, we'll see whether the Comprehensive Environmental Response, Compensation, and Liability Act, or CERCLA, imposed strict liability on site owners and waste generators after a release of hazardous substances. In 1972, Oscar Seidenberg and Harvey Hutchinson leased their warehouse to Columbia Organic Chemical Company. Columbia later incorporated into South Carolina Recycling and Disposal, or SCRD, and took over Columbia's waste handling business. SCRD contracted with off-site waste generators, including Monsanto and other companies, to transport and dispose of the company's hazardous substances. In 1977, both Seidenberg and Hutchinson learned that SCRD was storing hazardous waste in the warehouse. However, each landowner continued to accept rent payments from SCRD. Over the next few years, SCRD haphazardly stored and deposited more than 7,050 5-gallon drums of chemical waste in the warehouse. The waste was improperly stored in rusted drums, and several types of wastes were placed together, with no regard for potential chemical interactions. At one point, a toxic cloud formed over the warehouse after the waste had a chemical reaction with rainwater. In 1979, a fiery explosion erupted at the warehouse due to improper waste storage. The United States sued Seidenberg and Hutchinson, SCRD, Columbia, Monsanto, and the other waste generators under Section 107 of CERCLA. The United States claimed that all parties were jointly and severally liable for the costs to clean up the site, totaling over $1.8 million. Seidenberg and Hutchinson argued that they couldn't be held liable because they were absentee site owners. The waste generators claimed they weren't liable for the costs because none of their specific wastes contributed to the hazardous conditions. The parties all argued that CERCLA liability was retroactive and therefore unconstitutional. The district court granted a summary judgment and held that all parties were strictly and jointly and severally liable under CERCLA. The district court also held that CERCLA wasn't retroactive as it imposes a prospective responsibility for past acts. Even if CERCLA was retroactive, the court held that requiring parties to pay response costs for waste that they released is constitutional because it serves a valid legislative purpose. Seidenberg, Hutchinson, Monsanto, and the other waste generators appealed.